Are you considering consulting with an immigration attorney? Check out this short video for the top 10 frequently asked questions of immigration lawyers. Hey everybody, Barry here with the Lawful Channel. As you know, this is a great place to get short answers to the legal questions that affect our lives. If you haven't already, please subscribe to our channel, and if you have any questions or comments, put them in the comment section below. If I can't help you, I'll find someone who can. I'm here again today with immigration attorney Alan Taksh to talk about the second set of most frequently asked questions that an immigration attorney gets asked. Alan, thanks for getting together today.
My pleasure.
Okay, Alan, so what is the sixth most frequently asked question you get asked?
The sixth most frequently asked question also pertains to asylum law, specifically statements that accompany the actual I-589 asylum application. I get asked whether I, as the practitioner, can write that statement for the applicant. And the answer is unequivocally no. And for very good reason. Number one, it's unethical. If I'm asking you to write a statement, that is your statement. You are asserting what has happened to you and what is likely to happen to you if you return to your country. And so from an authenticity standpoint, it's very, very important for that voice to be yours. For that reason, I ask my clients to draft their own statements, but then to send me a draft of that statement. I then put on my officer hat and I analyze the statement from the vantage point of a would-be officer. And I ask things like, what did you mean by this? Where did they take you? What color was the car? Where was the building located? Where did they hit you? How hard did they hit you? What did they use to hit you? Did you get injured? Did you go to the hospital? Which hospital? And so I'm helping the individual think critically about the details of what has happened to them. But that is a far cry from drafting their statement. Again, from an ethics standpoint, it's incredibly important for the individual to write their own statement. They owe it to themselves. And quite frankly, the attorney can lose his or her license if they don't follow this simple piece of advice. Don't do it.
So with regard to the seventh most frequently asked question, you were saying that some people can get their citizenship as a result of the citizenship of their spouse. But what if their spouse is just a green card holder? How does that work out?
That's a good question, and the answer is slightly complicated. If the petitioning spouse is a green card holder, then it's very important for the beneficiary spouse to be in status. Why is that important? The beneficiary spouse has to be in status. Let's say he or she is on F1 student visa. Why? Because if they are not in status, then once the petition is filed by the green card holding spouse, the beneficiary will need to depart the United States in order to have his or her interview back home, also known as consular processing. But guess what? If that individual is without status and the spouse has petitioned for them and they depart the United States to go for their interview, let's say in Sao Paulo, in Brazil, well, they have now triggered either a 3-year or a 10-year bar as a result of having overstayed their visa and then departing the United States. Now they cannot come back for either 3 years or 10 years, depending on how long the overstay was in the United States. Importantly, that individual needs to be in status when the spouse is petitioning for them and remain in status all the way up to their interview in the United States. That way they can obtain their green card. It's a complicated area of law, and I suggest that individuals in this particular situation do their due diligence before departing the United States for their consular interview, because it may very well be a terrible idea for them to do so.
Okay, so what is the 8th most frequently asked question you get asked?
It's a topical one. It's one that involves the recreational use of marijuana. And the question is, how is the use of recreational marijuana going to affect my immigration case? And it's an incredibly topical one. Obviously, a lot of states are right now considering legalizing the recreational use of cannabis, and some have actually gone down that road, much like Illinois, starting in 2020, January 2020. Important for clients to understand that irrespective of the fact that your particular state may have legalized the recreational use of cannabis, in immigration, in the immigration space, it is still considered a crime. And so a lot of the applications you fill out ask you questions such as, have you ever used any illicit drugs? If you say no, and you have, you just lied. If you say yes, answering truthfully, and you have, you've just admitted to a crime. And so it has real life consequences. My advice to clients, say no to drugs.
Okay, for the 9th most frequently asked question, we're going back to green cards. So what is the 9th most frequently asked question you get asked?
I get prospective clients asking questions pertaining to their spouse having petitioned for them, the U.S. citizen's spouse having petitioned for them, and asking how long it will take for them to obtain a green card. The current trend in processing times is that within about 9 months or so, the individual should expect to have his or her interview, the adjustment of status interview. And again, based on current trends, I would say shortly thereafter, a matter of weeks, they should expect to receive their green card in the mail. So all in all, based on, I keep saying, current trends, June of 2019, it takes about 10 months if you cross your T's and dot your I's and proceed with utmost due diligence.
Okay, and the 10th most frequently asked question you get asked is?
I get asked by clients, I filed my asylum application, I went to the interview by myself, my case was referred to immigration court. How long should I expect to wait until I've had an opportunity to present my case in front of an immigration judge, also known as an individual hearing? Based on current trends, it takes about 2.5 to 3 years for the individual to be scheduled for their trial. There are approximately 850,000 pending cases in immigration courts across the United States right now, as of June of 2019. So when we say the immigration system is broken, it's not an hyperbole. It's very much broken. And so you have 850,000 cases that are on backlog. You have individuals who are every day filing applications, hence adding to the wait. So if you file your application today, affirmatively, you go to your asylum interview, 2 months, you get referred to immigration court, you're expecting to probably see your individual hearing sometime in 2022.
Okay, Alan, thanks a lot for getting together to share all this valuable information on immigration law.
My pleasure.
And thank you for checking out this 2-part series on the top 10 most frequently asked immigration law questions. If you have any questions or comments about immigration law, please put them down in the section below. And if you have any legal issues that you need some help with, please feel free to reach out to me. If I can't help you, I'll find someone who can.